And if you think about it, you know, it's still an office facility. It's not really the definition of community facilities. And I mean, it can still go alongside shops and things like that, but not in the residential areas. Yeah, yeah, that's right. Yeah, it could go anywhere. Yeah. All right, good.
Good afternoon. So I hope that we could finish the resolutions today to approve these chapters in section 32 reports to go through to the Minister. We will start with the resolutions for the city centre.
Yep.
That's to do with the city centre chapter, and I'll hand you over to Peter Eamon while I put an additional resolution up there.
Great, thank you.
Number. This one's wrong. Activities. Okay. We'll start with the commercial zones. A lot of these are ones that you've actually seen previously at the presentation, and they're pretty small things. So the first one is to insert appropriate clause numbers. That's where our electronic system somehow put a whole lot of zeros in some of the clause numbers.
Yep.
And the second one relates to deleting yard-based suppliers in the south frame.
Can we see it? Just can we float up?
That's what it should be.
Sorry, we're trying to do two things at once. Can we scroll up the amendments, please? Can we scroll up the existing ones?
Scott?
Sorry, can we scroll up the existing ones? Yeah. So, no, go back, not that far. Not that far. I know that you're working over there, but we want to see what we're voting on in the meantime. Right, that's great. Yes, it is. Yard-based suppliers. So we've got insert the appropriate clause numbers into the rules. No problem with that. And delete item 5, plan implementation, detail yard-based suppliers in the south frame from the commercial zone, section 32. All right?
Okay.
Someone like...
Sorry, no, that's fine.
Well, I was just going to move it.
Yes.
I mean, it seems sensible to me.
Yeah, no, that's fine.
Yep. Paul, you'd like to move it? And David would like to second it. I'll put that motion. Yep.
Can you just tell me I'm not quite sure of the impact of that. Maybe I'll miss the discussion another day.
The yard-based suppliers?
By taking out the yard-based suppliers from there. Is that what it does?
Because, in fact, there have been no change to yard-based suppliers. They were already, from memory, non-compliant activities, yes, and they remain non-compliant activities, so there was no reason to highlight that in the section 32 because we weren't changing anything.
Okay.
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 I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. So, did you get the mover and the seconder? That was moved by Paul Lonsdale, seconded by David East. Great. Next one.
So this is the first of the new ones, the two new ones, which is proposing to remove both emergency service facilities and
Community corrections
facilities.
Yeah. As permitted activities.
As permitted activities.
But you're going to replace emergency services with central city restricted discretionary.
Restrictionary.
Yeah.
And community corrections facilities will become, by default, fully discretionary.
So we're just having delete that activity, community corrections facility.
Yeah. Yep. All right. So, yep.
Discretionary activity.
No, there won't be.
There won't be, and there's nothing in there to suggest limited notification for restricted discretionary either, so there won't be.
Like the key issue with the community corrections, aside from whether it's suitable for a residential neighbourhood, has been the lack of public notification. So I just want to make sure that there is something in there that means that it should be notified. What I'm hearing you say is even if we take it out, there could still be the discretionary consent non-notified to go in, and that's probably what would
Well, there's,
They can
the
see-
provisions that we're able to put in there is if we're going to limit notification. Otherwise, the council needs to go through the process of deciding whether or not to notify.
Right, I think I'm probably talking at cross purposes. So when you say limit notification,
Yep.
That means less notification to the community?
Or no notification. You can actually specify that non-compliance with the rule will be non-notified and no neighbours can see. No, we're not limiting them, because if we were, it would be up in that box.
Right, okay, so it'll go through the normal test.
Yes.
Then obviously the higher threshold would be to make them publicly notified activity, and we can do that as well.
Yes, you have completely the option to do either, according to the considerations that the Act contains.
Statement of expectations, and given this is in the CCRP, you would need to consider that.
So worst case scenario, if there's into community corrections in a residential area, we could say...
I'm not accepting and putting this forward that this is a PD centre.
That's right.
It's not. We've already been told
Yeah.
that detention does not apply.
I don't agree that that's the case. There's nothing...
Well, but we've had advice that that is the case. I mean,
So can staff just say categorically that a community corrections centre will not have any periodic detention or any type of activities that would be associated with a PD centre in the past?
it's custodial. Custodial it doesn't apply to.
The definition that I read out earlier is non-custodial.
Yeah.
It specifically uses the word it's administrative and non-custodial. I'll also add that I've also noted that in terms of the material that's before you today, that definition hasn't been drafted in yet as well. So if you wanted to maintain some form of community corrections facility as
I've got Harry here.
as a defined term, that definition would need to be added.
So the recommendation from the staff is we can't go back and change what has gone through the hearings for the residential stage 1 at this stage. They
Yeah.
are complete, although the decision isn't released.
Yeah, but we can do this.
Yes.
Yeah. All right. Yeah.
That's
So and that's what we should encourage. But make sure when you encourage people to make submissions that you don't
they understand it.
mislead them about what a community corrections facility is, and by then we will have a definitive definition. All right, so well, I'll move that. Would someone like to second that motion? Phil, I'll put that. All those in favour say aye. Those opposed say no. That's carried. Right, next one. Central City School Zone.
Might as well have both up because they're both exactly the same thing, and it's just minor wording changes to
Okay.
get consistency with the names of roads.
Okay. So,
These are...
Innovation precinct.
the
These are
amendments don't do that. They change the name of the minor arterial to main distributor and local distributor as opposed to
I
collector.
get that, but in the
But that's
plan,
all we're voting on now.
no, but in the plan, commercial can still become school, and the innovation precinct can still have a university component in it.
They're non-complying activities.
That's got nothing to do with this amendment.
I don't know, I'd have to
So
look that up in the plan.
can we note that as a question? Can somebody get the answer to it before we actually vote on the final notification? So can we deal with 3.1 and 3.1.2 and 3.1.3 together as a single amendment, a resolution? So would someone like to move that? David, seconded by Paul. Yanni?
So these are matters of discretion So that's when an application is being sought, and these are things that need to be considered. And it's really just
like using a real life example, school development on Park Terrace.
Yep.
Presumably either a collector or a local distributor road. You'd have a higher level of discretion to assess traffic and transport than you otherwise would if it was just on a
okay. Well,
small side.
this resolution's got nothing to do with the level of discretion. It's simply stating what the matters are that are to be considered when a resource consent is required.
But I'm trying to understand whether it's favourable if it's on a local distributor road or if it's less favourable.
It just states what is going to be assessed. It doesn't indicate either way. It's just an assessment criteria.
It's a bit like an assessment criteria considering heritage values or something like that.
So that is
one of the things that is able to be considered as part of the consideration of the resource consent.
Yeah. Just clarifying wording.
Okay. And you're just changing the wording to reflect the current district plan in terms of the rating hierarchy?
Yes.
Yes.
It's to fit exactly with the transport section.
Right, I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. 3.1.4 Central City Flatland Recovery Zone Amendment.
Just before we move off the Central City education, so reducing or, under an RMA perspective, obviously sustainable management of the land and efficient utilisation for residential would be to have non-educational activities. So in light of what happened, which I want to try and avoid going forward, is it possible to have an amendment to make it harder for non-residential activity, particularly for schools, to go in residential zones within the central city?
I wasn't there for that discussion.
I'd need to get Glenda back because this was a question that was put to Glenda on Wednesday.
The rules in the Central City residential zone limit the size of education activities, and in fact a large number of non-residential activities. And there's also a whole list of controls in terms of hours of operation and various things like that.
The current district plan isn't, and even the new Central City plan isn't successful, in my view, doesn't have enough teeth around preventing the underutilisation of prime residential land for residential being used for alternative, non-sustainable, non-efficient uses.
Well,
So that we don't get the...
Can you write up an amendment for the particular clause that you want? I mean, we're going to have to. I mean, can we just go through these amendments and get these cleared away? These are the minor technical amendments that we need to get sorted out.
We're not really sort of discussing what's behind the thing. We're only actually changing the terminology.
Right. Yes, I know that. But what Councillor Johansson's raising is how do you propose amendments to chapters that we're going to sign off for sending to the ministers, knowing full well that if we don't get something in before they go to the minister, we can't change it when they come back unless the ministers raise them as issues. I mean, so, and that's something that I'm not sure that we can do in the time frame that we've got. So, but let's get the amendments out of the way, and then I think that rather than do one blanket resolution, we're going to have to do chapter by chapter, so we know specifically what chapters we're sending off to the minister, and if there are issues that people want to raise in that context, then we'll raise them. But I think the quicker we get through the amendments, these are technical amendments, the better. So can we carry on with these? Central City Flatland Recovery Zone amendments.
So I've sent around an updated version of this chapter, and I'm proposing some amendments following legal review feedback, as well as the amendments in terms of the questions that you raised on Wednesday.
Yep.
So you'll be able to see in red and strike through where I'm proposing changes, and I guess in summary it was to aid with clarification, or where there was duplication with the natural hazards chapter, to remove that. You'll see that P12 is, I'm proposing the new permitted activity for the stormwater or sort of basin works, but I can also update that in relation to your request earlier on this morning about making sure that that would cover wetlands and things like that. And also the removal of stop banks if necessary as well. So if there's anything you want me to elaborate on, then I'm
No, I
happy
think
to
that's
do
fine.
so.
I'm happy to move that.
Thank you.
Do I have a seconder for that? Do I have a seconder? Pauline? Yanni?
Non-residential, so, I mean, obviously Avon Loop is the classic one.
So this only applies to the Central City Flatland Recovery Zone area, which was, as I understand, previously all residential.
So the other area is already captured, is that why?
Anything outside the Central City is covered by the specific purpose Flatland Recovery chapter, which is coming up after this.
Oh yeah, but anything outside of the Flatland Recovery Zone in the Central City that has the natural hazards will already have this overlay. Yes. We're just extending it across the red zone.
No, this is just a zoning for.
We're looking at the resolution up the top, 3.1.4.
Right.
So it's not an overlay; it's just it's a zoning.
I'm just trying to understand, like in a residential area that's right next to a commercial area, that the only reason the commercial area wasn't red zoned is because it's commercial. So it's got the same identical characteristics, and I'm just trying to ensure that it has the same zoning.
It's my understanding that there weren't any commercial areas within the Central City that were red zoned.
This does not include land that wasn't red zoned, so it does only cover red zoned land.
Yeah. And are we confident enough that the assessment's been robust enough that it's a consistent approach?
The council wasn't responsible for deliberating on what was red zoned or not. That was the minister's decision. And so this is a holding pattern for that land.
It says very clearly this is a holding zone that will be subject to a later plan change to confirm the zoning pattern, which will be informed by the outcome of the residential red zone program.
That's fine.
I mean, it may well become residential again at some stage in the future. Depends entirely on the outcome of the future use. Yep. All right, so I've got a mover and a seconder. I'll put the motion. All those in favour say aye. Those opposed say no. That's carried. We did Central City natural hazards, do we? No,
So
we didn't.
This is a new provisions, basically to bring the Central City provisions in line with the natural hazard provisions applying to the rest of the city in respect of high hazard areas.
Yep. I'm happy to move that. Do I have a seconder? Yes, Paul. And there's just the, there's just the one motion required for this. Yep, I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. Right, next one. Central City Hospital Zone amendments.
So this is basically allowing the former Christchurch Women's Hospital to be used for activities permitted in residential zones if it's not used for hospital purposes.
Right. Okay, so who would like to move that? Paul, seconded. Andrew, I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. Central City Utilities amendments.
This is just deleting clauses out of the utilities section because they're already dealt with in the hazardous substances and contaminated land section.
All right. So I'll move that. Seconded by Glenn. I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. Central City Rules and Procedures amendments.
Okay, so these just added the appropriate map numbers you can see on the far right columns
Oh, yeah.
for identification, and then if we keep flicking down that table, the second resolution. Oh, sorry, you might want to pass that resolution first. Yes. Or if you want to do the two, and the other one was just to amend the Stonehurst accommodation scheduled site area to extend it to its full extent.
All right. Well, we can pass those as a single resolution.
I'm not in a position to answer that, but Alison might.
Is this for the Stonehurst accommodation or for? Mm-hmm.
Are carried through.
Well, the scheduled activities have standards that provide some additional development beyond what they would have through existing use rights. And those standards have been reviewed against what the zone standards are. So in some cases, for example, in the I think the residential zone, the setback from the road has gone from 3 meters to 2 meters. So I've updated the scheduled activity standards to match changes that have happened in the zone standards where that's appropriate. But generally, there hasn't been a large change in the standards for those scheduled activities.
Okay, so there's nothing in there that would surprise the community?
I wouldn't think so. I mean, there's not very significant changes from what's provided for at the moment. It's generally just matching changes that have happened through the zone rules to be consistent with those, but also keeping in mind that some of these activities are different from what would be anticipated for those communities, and then trying to, particularly with some of the landscaping rules, trying to provide for a little bit more.
Right, well, I'll move the two resolutions together. Pauline, I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. Central City definitions.
Right, so there's a number of amendments here, adding the definition for Central City, because some rules refer to that term rather than, say, referring to particular zones, so it's decided we needed a definition. Then the other changes were bringing the reliant and related definitions into the table. So that doesn't change the definition itself, it just advises people of what other definitions they may need to refer to in looking at that definition. And then a number of other minor changes to definitions.
All right, so can we deal with all three of them together? Is it 3 resolutions? Or 2? 3. Three resolutions together. Would someone like to move that? Jimmy, seconded by Paul. I'll put that motion. All those in favour say aye. Those opposed say no. That's carried. Central City Natural and Cultural Heritage.
I'll leave that to Caroline to talk to you about, because she knows much more about it than me.
Thanks, Peter. Just a handout from Kimberley relating to the resolutions there. The first one is in relation to the just making some clarification to the clauses that have immediate legal effect, and that's similar as you considered for Chapter 9. So it's some minor clarification points there. The second point is amend the chapter as shown in the document tabled, and that concerns in particular something also that you considered for Chapter 9 in relation to heritage upgrade works, going to a controlled activity status for Group 1 heritage items, and a clarification of the works and the settings to be not non-notified. And the third one is just a minor point to clarify something that's been proposed in the rules, to just confirm that we're not carrying over a specific exemption from noise standards in relation to heritage buildings. And the fourth one is some amendments to the Chapter 13 appendices for all of the schedules. So again, similar to the document you received for Chapter 9 about the lists of proposed heritage items, etc. So minor clarification points to mapping numbers, a proposed tree to not be included on the list, and some other minor points.
So this is an amendment to the section 32, is it?
Three of the amendments relate to, three of the amendments relate to the chapter, and one of the amendments relates to just a minor clarification point in the section 32 documentation.
Well, but it still contains the proposed listing for the building known as the former B south of Barnett's, prescribes the entire building.
Yes, so I understand that you resolved to make a different resolution on that today, so yeah, that what you've had tabled is the printout that was prepared prior to your resolution.
Right,
There is a cover-all recommendation at the very end of this long table for consequential amendments.
Okay, all right.
The other list, sorry, we had a list of bridges and things, which I'm assuming are part of this. Are any of those bridges in any way to be replaced in terms of flood mitigation or anything like that? Does it affect any proposed work on those bridges?
So in terms of the heritage items that are proposed, if a proposal came in for any type of development, that would need to be considered relative to the heritage listing. And what the impact would be on that heritage listing, but also in the context of flood mitigation. So it would be a RMA consideration.
Are we aware of the need to replace any of those bridges which we're currently proposing to list?
I'm not aware myself, but I could defer to one of our technical experts to see if they are aware of anything. I'll just say.
However, this is the same issue as this morning.
I understand the issue. I'm just also aware of the practicalities.
I've just had confirmation that there's no proposal to replace any of those.
Excellent.
bridges
Okay.
for those reasons.
Thank you. Any of the trees, are the trees in this list as well that we're doing?
So just to be clear on the question, so the trees are proposed in the listings. So are you asking whether any are proposed to be altered as a result of flood mitigation?
Is there, for example, is there any proposal that would affect any of those trees that you're aware of?
I'm not aware personally myself, but I guess that may come up, for instance, in the flatland recovery zone. It would be a matter of in due course, but Shane Moen, who's our city arborist, may have some information on that.
He probably has.